Hello, CRES students. This is Sam Zakarian with the Chicago Real Estate School. Today's session is going to be on Chapter 13. As I mentioned earlier, you get 45 questions, mostly from 16, but also 11 and 13. And this is going to talk about the real estate brokerage operation. So, starting on the 10th edition, page 186. Now, real estate brokerage operation. That very first paragraph, actually, you could highlight that. It says a real estate brokerage business can take on many different forms. It could be, it could be part of a national franchise like a Remax, Berkshire Hathaway, Century 21, Coldwell Banker. It could be an independent company as well. The office could be located in a office building, in a storefront, in a shopping center. They could have affinity relationships with lenders and attorneys and home inspectors. It's all up to the sponsoring broker how they want to set up their business. Now, the next paragraph they talk about, no matter how they set up their business, it doesn't matter. It's just the day-to-day activities of getting the business, keeping track of the escrow accounts, uh, marketing properties, uh, just the details every day. It's quite a bit. It's quite a bit. So for the sponsoring broker. Now, the third paragraph, they you don't have to highlight this, but they talk about virtual offices. Now, virtual offices were maybe about 10, 15 years ago. They're really coming into play, but they seem to be going back to the standard office, the brick and mortar type of office. They found out that um, having a virtual office, I mean, people need that energy that they connect with each other. I'm talking about the real estate agents. So a lot of companies are coming back to the um, actual offices, like the traditional offices, as I should say. Now, very next paragraph, I'd like you to highlight, put an X by where it says the managing broker and the sponsoring broker. Now, the sponsoring broker is a person that owns the office. Now, every office must have what's called a designated managing broker. We'll talk more about this in detail in 16, but I'm going to mention a few things right now. The designated managing broker, which could be the sponsoring broker, could be someone else, but they have to have a managing broker's license in order to be a designated managing broker. Now, a designated managing broker, the last paragraph you got to highlight, they take on additional responsibilities, making sure that they train the agents, handling all the escrow accounts, making sure that the company's policy is carried out. Now, again, to be a sponsoring broker or to be named as a designated managing broker, you had to take additional courses and you had to be, you must hold what's called a managing broker's license. Now, as a broker that all of you are going for right now, of course, you could list and sell any type of property, whether residential, commercial, industrial, farmland. You could lease, sell, and list any type of property. You must work for a sponsoring broker. To become a managing broker's license, you need to be licensed for 2 years as a broker before you can become a sponsoring broker or designated managing broker. Those are the requirements. But again, I will get into details about that in chapter 16. Now, on top of page 187, you can highlight the first couple of lines, put an X by the next 3 bullets. So I mentioned before, designated managing brokers, responsibilities and supervision. So they include, in the first bullet, supervision and training of all licensees and employees associated with each assigned office, implementing the company's policy, and supervision of all the sponsoring special accounts. I'm talking about the escrow accounts. It says, next paragraph, you can put X by that. In addition, designated managing brokers shall directly handle all earnest money, escrows, contract negotiations, and advertising for the brokers who haven't completed that 45 hours of what they call post brokers. That will be covered again in chapter 16 in detail. Now, let's go on to the middle of the page here where it says maintenance of licenses. You can highlight that one. It says sponsoring brokers are required to notify IDFPR in writing of the names and the license numbers of all the designated managing brokers and for which office they are responsible for. As far as supervision, you can go over these bullets on the bottom of this page. Just, you can highlight them, go over them on your own. Now, sponsoring broker. Let's go to page 188. The sponsoring broker is a person that owns the office. The sponsoring broker is a person that owns the office. They must have a managing broker's license. Now, and let's skip down to about the middle of the page where it says advertising. And you don't have to memorize the date. They had the August in there of 2019. Don't worry. All designated managing broker licensees who are named as a designated managing broker must indicate the status on all advertising, their business cards, letterheads, any advertising that they are the designated managing broker. Now, the last couple of paragraphs, they talk about planning. Now, honestly, agents will spend more time planning a 2-week vacation for them and their family than their entire real estate career. I mean, I'm telling you. It's very important to have your goals, set up your goals, write them down, follow them. We're going to talk about goals in a little bit, but that's very, very important, I think. In fact, you know what? I'm going to do that right now. I want to talk about goals. It's very important for people to set goals. So let me get to my board up here and I'm going to talk about goals. Everyone should always set goals, personal goals, business goals, career goals. So let me just tell you what it is. Goals should be written down. You must write down your goals. You got to look at your goals and look at them every day. Goals can be changed. Events happen. Let's say you had a goal today, this morning, that you're going to come into the office by 9 a.m. So you left your house at a reasonable time, but you got caught up in traffic. Maybe you got caught up in construction, or maybe there was an accident. Things happen, obstacles happen. You got to overcome their obstacles. You can't let those things stop you from achieving your goals. Now, goals have to be, they call them, they must be SMART goals. Goals must be SMART. What SMART stands for. Yes means they must be specific. The goals must be specific. You can't say, for example, I want to lose a lot of weight. You got to put down how many, I want to lose 20 pounds in the next 6 months, for example. And then you got to figure out your action plan as to what you're going to do. Are you going to eat less? You're going to exercise more, watch your calories, things like that. They have to be specific. They have to also be measurable. They have to be measurable. That means that you know exactly what you're going to do every month, every week, every day, every hour. The specific, measurable, they must be attainable. They must be attainable. Like if you're starting off new in a business, you have to be, the goals have to be attainable. You cannot say, hey, I'm going to, my first year, I'm going to earn $1 million in commission. They have to be attainable. They have to be, which leads us to the next one. They have to be realistic. Let's be realistic about what you could do. Again, goals could always be changed. Why don't you worry about that? And then they must be timed. Exactly what you're going to do. in the next 30 days, in the next 90 days, in the next 6 months. So that's what goals are. I would suggest that you pick up, so there's a lot of books on setting goals and tells you how to set them up. Or I do goal setting. I set up a goal setting in my training with my agents here. So you should be, need some help. I can help you out with that too. So now, let's go on to, still on page 189 now. Preparing a policy and procedure manual. Every office must have a policy and procedure manual to handle anything that might come up. Well, if an agent leaves, whether there's a dispute in the office, who's going to handle that? Who's going to make the decision? If there's any problems in the office with maybe someone drinking or drugs or smoking or things like that. So they must have a policy and procedure manual that everyone must follow because everyone must be treated fairly. And if they know exactly what consequences are, then they can't complain about it. So now in the middle of the page, they talk about safety concerns and appointments on showings. Definitely highlight that little paragraph there and the bullets underneath. Very important, agents deal with strangers all the time. And any profession that deals with strangers, there's always a risk there. You should never meet someone that you haven't even, someone called up on a property and you don't even know who they are, and you meet them at a house. You should never do that. Always ask your clients to come into the office. Come into the office. You need to, first of all, make sure they're qualified for what they want to see. You need to get their information, find out exactly what they're looking to buy before someone calls, hey, can you show me that house? So if you're doing open houses, I always suggest to agents, make sure I like to see agents doing open houses in pairs, two of them at a time. So, just for safety. I know a lot of places, homes have the cameras and stuff like that, but you got to just always think of your safety. Okay. So, there are a lot of safety tips out there. You can go to police department. I have Chicago Police Department coming to our office. They talk about safety tips for agents, and it's really a good idea. Now, business planning. We're up on top of page 190 right now. To stay on top of the changes in the real estate industry and practice, as well as keeping up with emerging technology, brokers should review and update policy manuals regularly. So now, 2 paragraphs down, unexpected loss of a designated managing broker. The first 3 lines you got to highlight, put an X by it. If a designated managing broker dies or quits, IDFPR must be notified within 15 days. You're going to hear this about at least 3 more times. So again, if I mention something or you read something 3, 4, 5, 6, 7 times, chances are that's going to be a question on a state exam. Now, the death of a self-sponsored broker, then IDFPR will honor the order of a court of competent jurisdiction appointing to be the representative of that sole proprietorship. The very next paragraph, put an X by change of business address. Now, if a sponsoring broker changes their address, they must notify the people that license us, IDFPR down in Springfield, within 24 hours. By the way, if you change your name, you change your address, you change your email, it is your responsibility, not your sponsoring brokers, your responsibility to notify IDFPR about your personal changes, whatever they might be. So let's go on to page 191. Let's see what this is all about. Errors and omission insurance. Now, the next 3 pages here, they talk about errors and omission insurance. Now, every agent must have errors and omission insurance. Now, what this protects an agent on is if they make a mistake on a contract or on a listing information sheet, they said that the rooms were 20 by 20 and they're 15 by 15. Basically, that's what errors and omission protects against. Now, every agent must have errors and omission insurance. They usually get this through their sponsoring broker. Make sure you understand what the fees are for errors and omission when you interview with a broker. I'll be talking about that a little bit later. So on these next few pages. Now, I'm going to go to page 193 right now. And it's like the second paragraph, independent contractors. Like you to highlight, put an X by that. Now, most licensed agents work as independent contractors. Now, being an independent contractor doesn't mean you can do whatever you want. It's how you get paid. Let's say you sold a property today and you earn a commission of $6,000. Your sponsoring broker will give you a check for $6,000, but you are responsible for paying your Social Security, the federal taxes, state taxes, insurance. You're responsible for that. You get a 1099 at the end of the year. That's if you're a independent contractor. You must still follow the office policies as well. Now, if you happen to be working as a employee, which very, very few agents do work as employees, then at that point, when you earn a commission check, your sponsoring broker will deduct for Social Security and state and federal taxes. They provide insurance, and then you get a W-2 at the end of the year. So let's go on to now page 194. Where they talk about a little bit past halfway down, independent contractor versus employee. Like you to highlight that paragraph, like you to highlight these bullets on the bottom half, and then the last two bullets deals with an employee. We already talked about that, but please go over that on your own. It's not that difficult to understand that. Now, let's go on to page 195. Right in the middle of page 195, where it says assistance. Like it to highlight, put an X by that paragraph, and highlight by all the bullets on the bottom of page 195. There's also one more on page 196. Now we're talking about personal assistants. Top producing agents they're doing a lot of business. They can't handle that themselves. They hire personal assistants. Now, there are two types of personal assistant. One is called a licensed personal assistant. The other is called an unlicensed personal assistant. Now, a licensed personal assistant is not a separate license. It's someone that has a broker's license, but instead of working directly for a broker and doing their own business, they're working for another broker in that office. Let me give you an example of what I'm talking about. Let's say that you are a licensed real estate broker and you're working for a sponsoring broker. You're doing a lot of business. You know, you're doing over 20, 30, 40, $50 million a year in business. You can't handle that yourself. You hired me to be your personal assistant. I happen to be a licensed real estate broker. Now, since I'm a licensed real estate broker, I could do anything that you could do. I could show property. I could host an open house. I can interpret contracts, negotiate contracts. I could do anything that you're able to do. Now, as far as paying me, because I'm licensed, anyone that's licensed can only get paid by their sponsoring broker. So whatever you're going to pay me, whether it's a percent of the sale price, whether it's a flat fee, whether it's an hourly rate, it doesn't matter. You can't pay me directly. You must pay our sponsoring broker, who then will pay me. That's if I happen to be licensed. Now, let's talk about unlicensed personal assistant. You are, again, a top producing agent, a broker working for a sponsoring broker. Again, you're doing 30, 40, $50 million a year, and you hire me to be your assistant, personal assistant. Now, I'm not licensed. Since I'm not licensed, I'm very limited as to what I could do. I could do any type of clerical type work. I could assemble documents. I could answer the phone. I could take messages. I could file papers. I could put up the sign. I could go get you lunch. I could do clerical type work only. But what's more important, if I'm not licensed, what I cannot do, very important to pay attention to this. I cannot show a house. I cannot host an open house. I cannot interpret contracts. negotiate contracts. I cannot do anything that a real estate license is required. Now, as far as paying me, you can pay me directly, but only in two forms. You can pay me an hourly rate or a flat fee, but you cannot pay me a percent of the commission if I'm not licensed. Only licensees could get paid a percent of the commission. And you can pay me directly, again, as I said. So let's go on to the bottom of page 196, the last paragraph. Termination of sponsorship. Now, let's say I'm your sponsoring broker, and you're a broker working in my office, and you decided to quit my company. Then what you do is you go online and you terminate to IDFPR website and you terminate your license. Now, once you terminate your license with IDFPR, you cannot sell real estate anymore until you find a new sponsoring broker. Now, if that new sponsoring broker happens to be right across the street from your office, and it takes you a whole minute to get there, once you get there, then your sponsoring broker will issue you your 45-day permit, which is your evidence of practice real estate, and then activate you with that sponsoring broker. Then you can start selling real estate. But until you find a new sponsoring broker, your license is considered inactive. So that's what happens if you decide to quit. What if I decide to terminate you? Then me as a sponsoring broker, I go online, I terminate your license through IDFPR website, and then again, you cannot practice real estate till you find a new sponsoring broker. IDFPR will notify you about the termination. Now, let's go on to page 197. Teams of brokers. Near the top here, you can highlight, put an X by that. There's a lot of companies that create teams for the brokers. You got to make sure you understand about it if they sign you to a team. You know, a company, and I know this for a fact, I know a lot of companies do that. They might hire you. Maybe I'm just making this up. Can't talk about commission. I'm just making something up. Maybe hire you at a 70% commission, but they sign you to a team. Now that team leader will get a portion of that 70%, as much as half, to be working on their team. A lot of times companies do that because they don't provide training, so they assign you to a team leader is what they call it. Now, working as a team, you can highlight that next paragraph. The important thing about a team is how they advertise. They got to make sure that their advertising cannot be construed as them being a real estate company. So these are the words that are not allowed. And you can highlight, put an X by these bullets right in the middle of the page. So you can't put this on any type of advertising, your website, your business cards, any type of advertising. You cannot use identify a team by company, realty, real estate, agency, associate, broker, property, or properties. Okay. It's just that it's kind of misleading. They think that you are a company and you're not. You're just a team. Now, also, the next three bullets we're talking about ads. Now, ads include everything: business cards, print ads, website ads, billboards, on a bus, skywriting, whatever you do. Now, those next three bullets, put an X by. This says the size of the licensee or team name cannot be larger than the sponsoring broker's company name. URL and domain names cannot be deceptive and cannot drive traffic. And then one click away rule. All right. Let me explain the one click rule. You can advertise a property, a house that's for sale. And someone could go on your website and they read the information on this property. And then they could one click, they could look, would you like to see other properties similar to this? So they click on that. Now, the thing is, when they click on, the very next thing they have to see that you are a licensed real estate company and who you work for, the name of your company. So they can't be looking at 2, 3, a dozen or 40 listings without knowing that you are a licensed real estate agent. That is what the one-click rule is. Now you see at the very bottom here on page 197, I gave you an example about your advertising. Again, your name or your team name, your personal name, if you're not part of a team, or your team name, ads cannot be larger than your sponsoring broker's company name. And if your company is let's say it's a Century 21 company, whatever the full name is, they just can't say Century 21. They have to say Century 21 Universal, Century 21 SGR, or whatever it might be. They got to get the full name in there. Just remember, on all advertising, your name could be equal or smaller than the company's full name. Now we're going on to page 198. Let's go on to the third paragraph down. You can highlight, put an X by sponsoring broker's compensation commission. It says the sponsoring broker's compensation is specified in the contract with the client, whether you're working with a buyer or a seller. So whatever your company policy allows you to charge or take a minimum, that's between you and your sponsoring broker. You got to remember, we're going to talk about this, but you cannot discuss commissions with anyone outside your own office. Now, as far as commissions, that next paragraph, you can highlight these bullets underneath. It says in there, underneath commissions, only a licensed designated managing or sponsoring broker may collect a commission in Illinois. And then they could share that with another co-op office. They could share it with their own agent. So make sure you highlight those bullets. Remember, the buyer agency agreement and the listing agreement is always between the sponsoring broker and the principal, the buyer or the seller. Remember, you work on behalf of your sponsoring broker. So now, second, at the bottom of page 198, the second bullet from the bottom, it says a complete sales contract has been executed by a ready, willing, and able buyer. You earn your commission as soon as you bring in a ready, willing, able buyer to buy that property, have a signed contract. That's when you earn your commission. But generally, the commission is not going to be paid until closing. Let's go on to page 199. The very top. You can highlight that and highlight the next three bullets. Be a little bit familiar with this. To be entitled to a commission, an individual, the first bullet, must be licensed as a real estate broker, be procuring cost of sale, the reason why that person bought that property, and be employed by the buyer or the seller under a valid contract, which is through your sponsoring broker, which means you must also have a sponsoring broker. Now, procuring cost of sale, you can highlight the next couple of paragraphs. Procuring cost of sale is the reason why that person bought that property. Procuring cost of sale is an uninterrupted chain of events without abandonment or without estrangement that leads to the successful closing of a contract. Now, let's see. Let's go on to towards the bottom, the last couple of paragraphs. They talk about commission structures. Now, every office is different. They cannot talk about what they charge for commission with other sponsoring brokers. So everything is always negotiable, whatever that sponsoring broker wants to do. And now they could offer a variety of commission splits with an agent. They can offer even 100% commission, but usually they have a kind of like a fee every month or a desk fee that they might call. They also a lot of times have other fees too, technology fees, even marketing fees, things like that. Every company is different, so that's why you really have to interview companies to make sure which one's going to be the right fit for you. Now, on page 200, the second paragraph, I'd like you to highlight, if a sponsoring broker licensee, a sponsor licensee, excuse me, has earned a commission, but its employment has been terminated prior to the payment of the commission, the former sponsoring broker may pay that commission directly to the former associate, even though they have a new sponsoring broker, which means this. You can only get paid by your sponsoring broker. You can only get paid by your sponsoring broker only. Now, if you were sponsored by one sponsoring broker and for some reason you quit and you went to another company before that one transaction you had with your former broker was to close, that's the only time they could get paid by anyone other than your sponsoring broker. The next paragraph, highlight, put an X by that one. The sponsoring broker's compensation and policy with cooperating brokers who represent other parties in a transaction must always be disclosed. And then if there's a compensation from two parties, that also needs to be disclosed in writing too. So, whatever I charge, say a seller for listing a property, that has to be disclosed to commission. How much of that compensation I'm going to share with another broker if they bring in a buyer, that also needs to be in writing inside that listing agreement right there. Now, sales force compensation. You got to highlight, put an X by that. The amount of compensation licensee receives from a sale is set by mutual agreement between the affiliated licensee and their sponsoring broker. So what you start off at, or what you get paid if you get hired by another company, is between you and that sponsoring broker. Now, the very next two lines, a line and a half, you can put an X by that. In many states, including Illinois, it is illegal for a sponsoring broker to pay commission to anyone other than, put an X by these next two bullets, a licensee under that same sponsoring broker or another firm sponsoring broker, which is in a cooperative compensation. Now, again, the only time you can get paid by a broker outside your own sponsoring broker is when you earn a commission with a sponsoring broker, but you left that office before it closed. I was mentioned that just a few minutes ago. Now, very next paragraph, highlight, put an X by that. Fees, commissions, and other compensation cannot be paid to anyone that's unlicensed for any services that legally require a real estate license. There is one exception to this, and I will bring that up in a little bit, actually in chapter 16. Now, the last paragraph, highlight, put an X where it says under the act, just to let you know, a licensee can form a corporation just for one purpose of receiving commission or compensation. If you form a corporation, you must notify, send a charter down to Springfield to let them know, and then your sponsoring broker can pay your corporation. But you have to understand, you must sell under your own name. You cannot sell under your corporation name. People do that for tax purposes. Make sure you follow that as well. Now, page 201 at the very top, technology and brokerage of the future. Now, technology is a way that you can reach thousands of people in just a second. You need to send out things, let people know. I think I told you this on the very first day. Very important for you to contact everyone that you know that you're in a real estate business. Because if you don't, you're going to go to some event, some party, a barbecue, a holiday event, or something with the family and friends. You're going to find out that they bought or sold a property. They listed a property with another agent, or they bought a property. Well, why didn't they call you? Well, if they don't know you're in a business, they can't call you. That's why you need to notify them. Go on Facebook. Go on Twitter. Go to Hotspot. You got to let people know that you're in a real estate business. You got to put in content that people will find interesting, like what the rates are. Let them know everything that you're doing. Let them know that you're taking a real estate class. You're going through some training, that you did a showing, that you just wrote up an offer. You just came back from a closing. Let them know your activity, even if they're out of your market area, because you always do referrals. Make sure you do that. Now, antitrust. It says antitrust violations include price fixing, group boycotting, allocation of customers, allocation of market, and tie-in agreements. So let me go over these with you. Now, the first couple of paragraphs on the price fixing, you can put X's by both of them. Price fixing. Price fixing is when two agents from two different offices discuss what they charge for commission. That is illegal. It's called price fixing. It's called collusion. It's called restraint of trade. It's part of the Sherman antitrust laws. Now, agents from the same office can agree on a minimum commission, but they cannot discuss it with anyone outside their own office. So price fixing is illegal. At the bottom, group boycotting. Group boycotting goes on. That would say, let's say, for example, I'll just make up some names that Century 21, Coldwell Banker, Remax, Berkshire Hathaway. They say, you know what? We're not going to show properties listed by, I don't know, Keller Williams, for example. Can't do that. Can't do that. That's group boycotting is illegal. You've got to make sure that you show everything that's available to your clients that fits in their budget and fits in their needs. Let's go on to allocation of customers or markets. At the very bottom of 201, but the first paragraph you got to highlight on 302. Allocation of customers or market. That's illegal. Tell you what. Coldwell Banker, you can only sell property in Lakeview. Berkshire Hathaway, you can only sell property in Lincoln Park. Keller Williams, you can only sell property in Wrigleyville. No, your license says state of Illinois. So you can sell property anywhere in the state of Illinois. You cannot assign territories or markets or sponsoring broker says, no, that's my territory. You can't sell there. That's illegal. Tie-in agreements. Yeah, highlight for that. By that, tie-in agreements, I'll give you a couple of examples. Let's say you hire me to sell your home here in Chicago. I sold your home here in Chicago. And now you want to buy another home. Maybe you want to buy a home on a far south side suburbs of Orland Park. Now, if you want to use me, that's fine. I cannot make you use me. Just because I sold your home here in Chicago doesn't mean I can make you use me when you want to buy a home in Orland Park. I mean, you might want to use an agent in Orland Park, an agent that's familiar with the culture, with the activities, with the school. Now, if you want to use me, that's fine, but I cannot make you use me. Tie-in agreements are illegal. Another example of a tie-in agreement. If you buy a home from me, you must use my attorney, my loan officer, my home inspector. I can recommend people to you. You should always recommend up to 3, but I cannot make you use them. Now, in the middle of the page where it says, do not call registry, you got to put X by that paragraph. Now, there are people that are on a do not call list. Now, they have to, people think if they sign up once, they're on there forever. This started in 2003. Now, if you sign up for that, it's only good for 5 years. Every 5 years, you got to re-sign up for that. Now, if someone's on a do not call list, you cannot call them to solicit business. I mean, if you have a business relationship with them, they give you a number, you're helping them, that's different, okay? The fines, they've been kind of watching this a lot, so you got to be careful about contacting people. You got to follow the rules, check with your company's office policy. They should have a way to find out, it's available online, who might be on the do not call list. Now, let's go on to, one thing I want to say about the do not call list. It's the second paragraph from the bottom, still on page 202. Now, if someone's on a do not call list and you have a business relationship with them, you've been working with them, showing them homes, they bought a home, they sold a home through you, even if they're on a do not call list, if you have a business relationship with them, you have a right to continue to contact them for up to 18 months once that business relationship has terminated. Second paragraph from the bottom on page 202. Now let's go to page 203. About the middle of the page, Cam Spam Act. Got a highlight for the X by that. Now, if you're going to send out junk spam out to people, that's okay to do that. But if they want to unsubscribe, you got to give them, there has to be a line in there if they get check off that they don't want to receive these anymore. It has to be in the same um, information that you send them. And you can go over the rest of this page on your own. Let's go to page 204, about a third of the way down. Junk Fax Prevention Act. I still see this on the exam. Now, if you're going to send out junk faxes out to people, that's okay to do that. But you got to make sure if they don't want to receive them, there has to be on the same fax that you send them. If they want to opt out, they can. They must be able to opt out if they don't want to receive any more of your junk faxes. So just be aware of that. Now, the last two paragraphs of page 204, state licensing law. Now, every state has real estate licensing law. The purpose of real estate licensing law is to evaluate the competency of people engaged in a business for the protection of the public, not the protection of us, licensees, for the protection of the public. Now, let's go on to page 205. After the bullets, the second paragraph where it says brokerage agreement. I'd like you to highlight, put an X by that. Now, brokerage agreements are employment agreement. It's for the personal, professional services of that sponsoring broker between the seller of the property or the buyer of that property. Now, remember, all the buyers, all the sellers always belong to the sponsoring broker. You work on behalf of that sponsoring broker. Now, whether it's a management agreement, listen agreement, buyer agency agreement. Now, and they have to be in writing too. Now, I'm going to talk about types of listen agreements, but one thing I want to mention, and let's go to page 206. The first two paragraphs, I'd like you to highlight, put X's by it. Expiration of the brokerage agreement. Every listen agreement with the seller, every buyer agency agreement with the buyer must have a definite termination date. You cannot list a property until it sells. You cannot list a property forever. You must have a definite termination date. It is a loss of license. You can get fined up to $25,000 if you don't do that. And that second paragraph, no such thing as automatic renewal on a buyer agency agreement or the listing agreement with the seller. Meaning that I list your home for 4 months. Doesn't sell in 4 months, automatically renews. No. The listing expires in 4 months, then we must do a new listing agreement. Or the buyer agency agreement expires in a month or 2 months, or whatever we have, we must do a new buyer agency agreement. Now, very important for these types of listing agreements, because generally you're going to get anywhere from 4 to 6 questions on these 4 types of listing agreement. Right in the middle of the page here on 206, where it says exclusive right to sell listing agreement, highlight that entire paragraph. I want you to put an X by that paragraph. And then the very next paragraph where it says exclusive agency listing agreement, I'd like you to highlight, put an X by that paragraph as well. The very next paragraph, open listing agreement, highlight, put an X by that one as well. And then near the top of page 207, where it says net listing, I'd like you to highlight, put an X by that one. Now, these are all very, very important. So what I want to do is I want to write these things out for you. And I told you before, if I write something down, it's really good for you to copy it down. I know you can take a picture of it, screenshot it if you like, but by writing things down, you tend to retain more of that information. For somewhat, I don't know whatever reason it is, you write things down, it goes up your arm and next to your brain for some reason. So let me write these down, these different types of listing agreements. So the first one, I guess you should get about, I don't know, I'm guessing 4 to 5, 6 questions on this. First one is called an exclusive right to sell listing agreement. Exclusive right to sell. Exclusive right to list, excuse me. List. Agreement. Now, probably this is the most common type of listing agreement that's out there. Now, an exclusive right to listing agreement the seller only signs up with one sponsoring broker, only with one sponsoring broker. Now, if that broker sells a property or any other broker sells that property, the listing broker will get paid. Most common type of listing agreement is exclusive right to sell listing agreement. They only sign up with only one sponsoring broker. If that broker sells a property or any other broker sells a property, that listing broker will get paid. So on this one right here, you're only going to see one sign in front of the property. For sale by, let's say, ABC Realty. Now, number two, called exclusive agency listing agreement. Exclusive agency listing agreement. Now, exclusive agency listing agreement, the seller only signs up with one sponsoring broker. Now, if that broker sells a property or any other broker sells a property, that listing broker will get paid. But the seller reserves a right to sell their property on their own to their own buyer, and they would not have to pay commission. On something like this, you will probably see two signs in the front lawn. I have one that says for sale by ABC Realty, and you will also see for sale by owner. So if the owner sells a property on their own to their own buyers, they will not have to pay commission. Number three, they call this a open listing agreement. Now, in an open listing agreement, the seller can list their property with as many brokers as they want. They only pay commission to the one that what we call procuring cause of sale. They can have 100 signs in front of their property. Now, I guess maybe I will guess most brokers will not accept that because why will you put an effort into selling a property and there's a chance you're not going to get paid? So, by the way, in an open listing agreement, if the seller sells a property on their own to their own buyers, they will not have to pay commission. Now, this next one is called the net listing. So make sure you go over all of these, read everything, but I'm explaining everything to you. Now, a net listing means that the seller wants a certain amount of money for the property. Anything above that amount, the agent can keep or the sponsoring broker can keep as their own net listing. Now, the thing about net listings, even though they are legal here in the state of Illinois, net listings are considered unethical. They're considered undesirable. They take advantage of a certain class of people. The class of people they take advantage generally might be the elderly because maybe someone bought their home 30 years ago and they don't know the value of their home today. They tell an agent, I want $350 for the property. They don't know the value. They think that's really a lot. And the agent, and anything above that, the agent can keep as their commission. But the agent knows that the value is really $450. And let me give you an example, and maybe you understand this a little bit better. I'll give you an example. So let me I'll turn off my phone. So sorry about that. Now, okay, we're going to do a net listing. Seller wants a certain amount. Anything above that amount, the agent can keep as their commission. So you took a net listing, and the value of this property, the true value is $450,000. But you have a net listing that the seller wants a certain amount. They want $350. Anything above that is your commission. That's what a net listing is. So they get $350. Anything above that is your commission. Now, here's what happened. You listed the property at the true value of $450,000. And let's say it sold for $450. Your commission that you will net out is $100,000. Now, even though this is legal, believe me, you're going to have a problem with this. We cannot take advantage of someone's lack of knowledge and use it against them. Now, here's a very important question I want to ask you. Pay attention to this. A lot of people get it wrong. Now, I took a net listing at $350,000. Anything above that amount is my commission. Okay. Now I listed the property at $450,000, and we sold and closed on this property. Yet I did not earn a commission. And the question is why? Let me repeat this question to you. Very important. I took a net listing. You said, Sam, anything over $350,000 is your commission. But I listed it at the true value of $450,000. And I sold this property. And I closed on this property. Yet I did not earn a commission. And the question is why? The answer is really simple. The property sold for $350 or less. See, I had to present any and all offers, even though I have it listed at $450. I have a net listing. Anything over $350 is my commission. But someone comes in with an offer of $350 or $345 or $340. I had to present that to you. And if you accepted it, then I earn nothing. You understand that? Watch the tape, rewind it, and watch it again. Now, a couple other things. There are 4 listings I put up there on the board. Exclusive right to list, listing agreement, exclusive agency listing agreement, open listing agreement, net listing. Here's a question. Under Illinois law, which one of these mandatory under Illinois law must be in writing? Is it, well, just tell me which one you think it is, or why don't you write it down? Now, if you picked out number 1, that will be wrong. If you picked out number 2, that will be wrong. If you pick out number 3, that will be wrong. If you pick out number 4, that will be wrong. If you pick out all of them, that will be wrong. If you pick out none of them, that will be wrong. The answer is, in 1 second. The answer is going to be 1 and 2. 1 and 2. You had to take both of them. Any exclusive agreement mandatory must be in writing. And if you forgot about it, on your textbook, go to page 163, the 10th edition. If you have the 9th edition, it's on page 173. Any exclusive agreement, it's right in the middle of the page. I told you to highlight, I told you to put an X by it. Any exclusive agreement, mandatory, must be in writing. Now, another question for you. which of these listen agreements can the seller sell on their own and they will not have to pay a commission? Which one of these can the seller sell on their own and they will not have to pay a commission? The answer is going to be 2 and 3. 2 and 3. Under 2 and 3, the seller has a right to sell their property on their own. They would not have to pay a commission. You can't pick out just 2. You can't just pick out 3. You have to pick out the answers 2 and 3. So I got a couple of those questions in the back of this chapter, and I like to make sure you go over them. Well, you have to anyway. Now, the very last paragraph on page 207, guaranteed sales plan, offices, agents offer guaranteed sales plan. I'm going to skip that for right now because I am going to cover that in detail when we get into chapter 16. Now, let's go on to page 208. Page 208. Well, it's right there, what I just said to you, the first 2 lines. In Illinois, any exclusive or non-exclusive listen agreement must be in writing and subject to other legal requirements under the License Act of 2000. Now, the next 1, 2, 3, 4, 5 paragraphs, you got highlight, put X's by. They talk about the multiple listing service. Now, the multiple listing service is a database that we pay for, that we have access to all the properties that are for sale, properties that are under contract, properties that have sold, haven't sold. That's what the multiple listing is. It's a huge database. And in the United States, we belong to the world's largest multiple listing service, MLSNI, Multiple Listing Service of Northern Illinois. They combine several boards together, and you can pretty much search property from almost anywhere, but the top half of the United States, Indiana, even Iowa, southern Wisconsin, and even outside of that area, even in different countries too. Now, you can go over all these paragraphs here on page 208, but the last one, let me go over this one with you. Termination of the listen agreement, to put an X by that. Because the licensing services are unique, a brokerage agreement cannot be assigned to another licensee without the principal written consent. So the services are very, very unique. So you cannot assign or transfer that to someone else. Now, on page 209, after that second paragraph, that one line that says, listen agreements can be terminated for the following reason. You can highlight these bullets. Let me go over these with you quickly. When the listen purpose is fulfilled, that means you brought in a ready, willing, able buyer and you're able to close on it. That is the best way of terminating a listen agreement. Another one is when the listen agreement term expires. The next bullet, the property is destroyed or uses changed by some force outside the owner's control, like a zoning change or condemnation by eminent domain. Next bullet, if title to the property is transferred by operation of law, like in a bankruptcy or foreclosure. Next bullet, if the sponsoring broker and the seller mutually agree to cancel the agreement. Now, which is very important, there's a couple X's by this last bullet. If either the sponsoring broker or the seller dies or becomes incapacitated, that would terminate the agreement. If the sponsoring broker or the seller was to die, that would terminate the listen agreement. Now, pay attention to what I'm going to say. If you, the broker, was to die, it means nothing. Remember, the listen agreements between the buyer, listen agreements between the seller and the sponsoring broker. So the sponsoring broker dies, seller dies, that would terminate the agreement. If you were to die, it doesn't mean anything. I don't have a good way of telling you this. I want you to remember that. You should get a question right on that one if you remember what I just told you. Now, the next couple of paragraphs, the highlight for that. They talk about safety clause. See, all listing agreements have a safety clause. Now, the safety clause is in case, um, let's, let me ask you if you think this might happen in real life. Let's say that you have a listing that's on the market and it's getting ready to expire, maybe in a week from now. And you're bringing a buyer to see that property, and the seller sees that this buyer is really hot, very interested in this property. The seller gets hold of this buyer, pulls him aside and says, look, you're interested in this property. Why don't you wait a week? This listing is going to expire. Then you can buy from me and we save the commission. Let me ask you something. You think that happens? Sure it does. So we have a safety clause. It's called a safety clause, carryover clause, extended clause, that if you have a property listed and someone sees that property and they don't buy it while it's listed, they wait till it's expired and buy directly from you, we will get paid a commission for so many months, usually 6 months after. Now, if they relist it with someone else, that clause doesn't apply. But that's one thing that does protect them. Now, the listing process at the very bottom, you can highlight measuring the structure, the room count, you take the square footage, like that, you get off the tax records. You gotta get that information to fill out in a listing information sheet about the schools in the area, about things about shopping or the metro, the red line, things like that. Now on page 10, the fourth and fifth paragraph is qualifying the seller. Qualifying the seller. You got to find out what the seller's motivations are for selling. Sometimes they don't have any motivation. You can contact the seller and you talk to them and put his property on the market. Now, if they want to overprice a property, you need to walk away from that. An overpriced property, well, it's really against code of ethics to overprice a property. You're not doing the seller any justice by telling them. And even if you did sell an overpriced property, it's not going to close. And an overpriced property is going to take more time, energy, effort, and money just to try to get it sold. Still doesn't appraise out. Now, qualifying the seller is find out what their motivation is. What happens if your property doesn't sell? So, well, it doesn't sell. I'm going to stay here until I die. Not very motivating. What happens if your property doesn't sell? Yes, it's got to sell. I got job relocation. I'm moving all the way across the country. I got to sell. I got to get rid of this in the next 60 days. See, that's a motivated seller. You got to find out. Pricing the property, the next 3-4 paragraphs. Pricing the property, we do a market analysis. CMA, we call it. It's competitive market analysis. To help the seller determine the value of the property. You understand this. We are not appraisers and we do not appraise property. You cannot do that unless you are licensed and unless you're certified. What we do to help the seller price out the property is we do a competitive market analysis. And we compare it to current properties that are on the market, the properties that are under contract, the ones that have closed, the ones that didn't sell, have expired. So we got to analyze that and explain that to our client. Now, the last 2 lines of page 210 are market value to highlight for the X by that. Now, market value is the most probable price that a property will bring in an arm's length transaction, meaning both the buyer and the seller are informed. They know the value of the property. They're working in their own best interest. That is market value. Now, we go on to page 211. They talk about the first 3 paragraphs. They talk about doing a CMA to help the seller determine the value of the property. And just understand one more thing. The seller doesn't decide what the property is going to sell for. The real estate agent doesn't decide what the property is going to sell for. It's the market, which is the buyers, because they're going to tell us what they're willing to pay for the property. Now, information needed on the listing sheet. There is specific information, including tax, room numbers, things like that. Now, on the bottom half of 211, a listing agreement. In Illinois, the listing contract most commonly used are prepared by the local associations and their attorneys. They could vary from area to area. I like you to highlight. There are 4 bullets on this page. Highlight, put an X by them. There are 2 more bullets on page 212, the top. Highlight, put X's by those. Let me go over these things. Now, disclosure of a material fact, that first bullet. We're on page 211. A material fact is something that will cause someone to make a decision or not make a decision. An example of a material fact, again, basement floods out, there's foundation problems, the property taxes are going to trickle next year. You got to disclose material facts. Next bullet, disclosure of interest. If you, a licensed real estate broker, has any interest in that property, you have to disclose it in writing that you have some ownership interest in there. Otherwise, you can lose your license and get fined for that. Disclosure of special compensation. Now, a broker is prohibited from accepting any finder fees, commissions, discounts, kickbacks, or other compensation from any financial institution, title company, or any other person other than another licensee without full disclosure. So can you take a kickback? The answer is yes, you can. As long as you disclose it in writing to all parties involved, and it cannot be charged back to the client, and it must be paid to your sponsoring broker, who in turn will pay you. Because once you're licensed, you're going to get paid by your sponsoring broker only. Next bullet, earnest money and purchaser's default. Now, if the buyer defaults on the earnest money, and the earnest money is going to be paid to the listing office instead of the seller of the property, then that must be disclosed in the listing agreement in print that's larger than the regular text of that contract. Page 212, the first 2 paragraphs, disclosures. Now, there is a property disclosure required in Illinois. There is a radon disclosure required in Illinois, but the most common type of disclosure is the lead-based paint, 1978 lead-based paint. That's a federal law. It's the most common type of disclosure because it's across the entire country. So anything built before 1978, agents must give potential buyers or renters a copy of the lead-based paint disclosure and the pamphlet about the hazards of lead-based paint. Now, 2 paragraphs down where it says listing agreement content. Now, there's no required state form for any real estate contract, but usually you check with your board, check with your sponsoring broker, which is the most common type of listing agreement used in your area. What should be on there, you can highlight all these bullets here. Now, last couple lines of page 212, where it says broker's authority and responsibility. It says in here, contracts should specify whether the broker may place a sign on a property, advertise and market a property, put it on the internet, put it on multiple listings. Now, in order to hold an open house, in order to advertise on a multiple listing on the internet, to close an open house, put a sign in front of the property, you must have signed written permission from the seller in order to do that. And all those things are included in the listing agreement. They're all included in the listing agreement. Now, second paragraph on page 213, names of all party to the contract. Anybody that has an ownership interest in that property must sign the listing agreement to validate it. The rest of this, I want you to read over the rest of this page 213. I'd like you to go over that. Let's go to page 214. They tell you some of the obligations of both the buyer and the seller, encumbrances, zoning. Please go over this on your own. I'm not going to read all that part to you. Let's go on to page 215. The first paragraph there, home warranty program. Occasionally you're going to see this. A home warranty program protects the buyer, actually protects the seller while the property is listed. And once the transaction closes, usually the buyer is protected against any of the warranties that's listed in the home warranty program. It is a good idea to, you should always offer that when you take a listing and then have them sign off if they don't want to use it. That's up to them. Also offer it to the buyer. They can get a home protection plan in case things break down. You should do that. Now, let's go on to page 216. On page 216, the third paragraph, you get highlight the third and fourth paragraph, but exercise both of them. Now, the biggest print that you're going to see on a listing agreement has all the protected classes, the state of Illinois and federal, that you cannot discriminate. We're going to talk about discrimination in our next session. In the middle of the page where it says minimum services, make sure you highlight those two lines. Highlight, put an X by the next three bullets too. Minimum services, any exclusive agreement, whether with the buyer or the seller, you must provide these three bullets here, minimum services. Let me go over these with you. I want you to understand them. First bullet, accept the delivery of and present to the client all offers, no matter what. You got to present all offers and counter offers to buy, sell, or lease the client's property. Next bullet, assist the client in developing, communicating, negotiating, and presenting offers, counter offers, and notices that relate to the offers, counter offers until a lease or a purchase agreement is signed and all the contingencies are met, satisfied, or waived. Number three, answer the client's questions relating to the offer, counter offer, notices, and contingencies. Make sure you are aware of that. Let's go on to page 217. Now, in the middle of page 217, where it says buyer agency agreements, just like we have listing agreements, we have buyer agency agreements. I want you to highlight, put an X by that paragraph. And I want you to highlight, there are three types of buyer agency agreements. I want you to highlight, put an X by the last two paragraphs of page 217. I'm going to go over these with you. And then where near the top where it says open buyer agency agreement, like in a highlight, put an X by that one as well. Now, just like we have listing agreements, we have buyer agency agreements. So the first one, second paragraph on the bottom, those you highlight, put an X by it. This is called an exclusive buyer agency agreement. This is a mirror image of exclusive right to sell. See, in an exclusive buyer agency agreement, you sign up with only one broker. Now, if that broker finds you a home or any other broker finds you a home, even if you find a home on your own, you will have to pay a commission. The last paragraph, I told you to highlight, put an X by this, exclusive agency buyer agency agreement. This is a mirror image of a exclusive agency listing, number 2 over here. Now, in this one, they sign up with only one sponsoring broker. Now, if that broker, the buyer broker that they sign up with finds them a home, or any other broker finds them a home, they will have to pay commission to that one broker. But the buyer reserves a right to find a home on their own, and they will not have to pay a commission. Let's go to number 3, near the top of page 218. Open buyer agency agreement. That's a mirror image of an open listing agreement. Now, see, here's what I'm going to tell you what buyers think sometimes. If one agent could show the buyer 10 different homes, well, what if that buyer hired 10 agents? They get shown 10 different homes. That's 100 homes they can look at. Or better than that, what if that buyer hired 100 agents and they show them 10 different homes? That's 1,000 homes they can look at. They look at 1,000 homes, they're going to find the right home for them. Problem with that, and they only have to pay commission to the one that helps them procure that property. They can find a home on their own. Well, the problem with that is that we all belong to the same multiple listing. We all belong to the same multiple listing. See, an agent in Lake County doesn't have anything different than an agent in DuPage County. An agent in Will County doesn't have anything different than an agent in Cook County. An agent in Kane County doesn't have anything different than an agent in McHenry County. We belong to the same multiple listing. I mean, that buyer can hire 100 different agents. And the one that runs to the computer the quickest and show them the property, that's the only things they're going to see. You know why? There's only so many homes in the area that they're looking for, in the price range that they're looking for. So that they think wrong some. And now we have the exclusive, we have them sign that buyer agency agreement, the exclusive buyer agency agreement. I don't know. I mean, even though it's legal for a open buyer agency agreement, I don't know anyone that I don't know of anyone something like that. So now, couple paragraphs down, it says effective January 1st, 2025. Now, it is mandatory under Illinois law. You're working with a buyer and using an exclusive agency, exclusive buyer agency agreement that has to be signed by the buyer and the sponsoring broker before you even show them a property. You cannot even show them a property until you have this exclusive buyer agency agreement. Now, this also went in effect for showing apartments and commercial, also commercial property as well. As far as the buyer agent duties, include them over here. You could go over them, and services provided by a broker, which is the same relationship that you have with a listing with a seller as well. You can go over these bullets on top of page 219 here and just go over those. Let's go on to towards the bottom of page 219, where it talks about buyer representation, agency disclosures. I like you to highlight for the X by that what you should, what should a broker do? Oh, this is just an example of a role playing over there, so we can skip that. But let's go on to page 220. Near the top, where it says the buying process. I'd like you to highlight for the X by that. You can highlight these 5 bullets underneath. Also, the next couple paragraphs as well. Now, the property condition, how long it's been on the market. You got to keep your buyers informed of everything that's going on with that property. Now, also, the second paragraph from the bottom, presenting and negotiating the offer. So you got to make sure that your client is qualified. You have a letter from the lender, how much they could afford to buy that property. You got to make sure you hook them up with a home inspector and an attorney and a lender. That is your job. Now, the last paragraph of this page here on 220, I'd like you to highlight for the X by that, disclosure of contemporaneous offers. Let me explain this to you. Contemporaneous offers. I have 2 buyers interested in buying the same property. I am allowed to work with both these buyers. I just can't tell the first buyer what the second buyer is going to offer for the terms of the agreement. I cannot tell the second buyer what the first buyer is going to offer. Okay, you got to keep that separate. But you can work. You can let them know, hey, look, I have another client interested in this property. I cannot discuss anything about that, but I do have another client that's making an offer. You can do that. Now, on page 221, after the second paragraph, letter of intent for commercial purchases. You can highlight, you can put an X by those 4 paragraphs there. Letter of intent. Whenever you lease commercial property or you sell commercial property, before you type up the lease, before you type up the sales contract, you do a letter of intent. Letter of intent, also called a LOI, which is what both the landlord and a tenant agree to, or the buyer and the seller agree to, and they put this all together in a letter of intent. Then this is going to be transposed onto the lease or onto the sales contract. Now, Actually, the rest of this page on 221, you can read that on your own. On page 222, about a third of the way down, multiple offers, you can highlight the next four paragraphs. Now, with multiple offers, you've got to present any and all offers, and you should have them in an organized situation. Say you got 5 offers on a property, you got 5 offers. You take a sheet, you mark down, you write down what it is, what the down payment is. Oh, I got the one. You mark down what the down payment is. You might write down the interest rate. Put it all together in a list. Interest rate. Might do the closing date. Of course, you must do the purchase price. All the terms, and you let them, you provide them for the seller, and then they can make their decision as to which one is the best one. Don't make the decision and they should take this one or that one. You have to present and put all the pros and cons of it. You got to make sure the interest rate is realistic. You got to make sure that they can get a conventional loan with 2% down. No, you can't. Well, that's your job to investigate on it. And that is the end of chapter 13. I know it's a long chapter. So, again, make sure you do the chapter quizzes, because you can't take the state exam till you do all the chapter quizzes. We're down to about 3 more chapters, and then I'm going to do a math video too. So, again, this is Sam Zakarian saying, do the studies. You have any questions, talk to your instructor, or you can email the school, and please make sure you stay current with the questions at the end of every single chapter. So again, until I see you on the next video, Sam Zakarian saying goodbye for now. Thank you very much for your attention.